What up, what up, what up, what up, Atmosville? How y'all doing? How is my family? I missed y'all. Been gone for a couple of days. I'm so glad to see y'all back for us to go ahead and finish this up and wrap up this case, y'all. But y'all already know what we got to do, man. Y'all already know what we got to do. Let me see who up in here rocking with me today. Who up in here rocking with me? TLM, how are you? How are you? Conchita, hello. Cherie Harris, what's good? Let me see. Black Diamond in the building. Hello. Laura Zeffin. Hello. Jill Small. Hello. How are you? Love is fair. What's going on, my brother? How are you? Rocking with the Truthers in the building. T-Bam 1. What's going on? I'm a Queen Newton in the building. What's going on? Let me see. Who else? So Icy is in the building. West Coast Bells is here. Hello. Let me see. Davis Campos is here. Be the Light is here. And also, we have NV1 Higgins. And then we have Tanya with the Sleepy T is in the building. Also, I'll bring you up here in a minute, Tanya. I'll bring you up in just one moment. But before I bring you up, y'all know what we got to do. Let's go!
1, 2, 3, welcome to the show. 1, 2, 3, welcome to the show. Can you?
Grab me a positive synergy. I have been doubted through life. Been there and done it with trifling people who told me my style would not work. I told them they wrong. Been struggling too long. This song is for you. I'm proving you wrong. Get out my way. 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 Get out my way.
Let's go, y'all. What's going on? What's going on? What's going on? How y'all doing? How is everybody? So great to see y'all. What up, Ike Nice? What's going on? What's going on? All right, y'all. So check this out. Tell you what the Sleepy T, what's going on?
How are you doing tonight?
I'm doing great. How are you?
I'm good, thank you. Good to be here.
How are the kiddos?
Annoying. They don't want to sleep.
Hey,
the little one.
That's their job, man. They got to, you know what I'm saying?
They're lucky they're cute. I tell you what.
Ain't nothing wrong with that, man. Nothing wrong with that. So y'all check this out. So I got some info here. There are still some cases going on from people that are attached to this R. Kelly case, believe it or not. I believe Don Russell's got some stuff coming up pretty soon. And also the Boski gun. That was the person that they called a super fan who was in New York and, you know, made the terroristic threats on that building. Do you remember that, Tanya?
Sure do. I can't wait to hear this juice. I can't wait to hear it.
Well, I found some information. I know a lot of people been asking, well, what's going on with him? Have you heard anything? And I did. I found some information on the latest on the Boski gun. All right, Nice. What's up, bro?
What's happening, y'all? How y'all doing, man? How was our weekend?
Good, man. Can't complain. Can't complain,
Hey.
brother. So let me show y'all. Let me show y'all what's going on. Let me just share my screen with y'all. And here we go. Give me one moment here. Here we go. So this here is just the latest on Mr. Boski gun. Let's see here. So this here is, he actually had a, let me make sure y'all can actually see this. Let me go over here. Okay, y'all can see it. Let me just bring it in a little bit. Do I have this here? Yeah. So this right here looks like it was a motion to, let's see here. It says it's for the federal offenders. The Honorable Hector Gonzalez. This was put out on August the 2nd. It says here, Dear Judge Gonzalez, this is from his lawyer. His lawyer said, with no objection from the government or pretrial services, I am writing to respectfully request that the court permit Mr. Gunn to leave his home to renew his driver's license. Mr. Gunn will need a renewed license to be able to travel to his court-ordered mental health treatment. If the court grants this request, pretrial services will coordinate with Mr. Gunn and give him a schedule for his trip. Respectfully submitted, Allegra Glasshouser. That was this assistant federal defenders. Okay, so this is what he put in, saying that he would like to be able to, you know, go and, you know, go get his driver's license, which, you know, the man needs his driver's license, right? I would agree with that.
Because he definitely needs those services for sure.
Yeah,
he needs to be there at those appointments.
He does need the mental stuff. He needs that, right? Now, there was something else that came out that I found. Let me share this with y'all. Let me just get rid of this right quick. And then let me pull this up. So we're going to share. With my daughter, she watches Coco Melon. So she always say that song, sharing is caring and sharing is fun. If we all share together, then share with everyone. All right,
I know that song, Atmos. I know that one.
So we're just sharing information. That's it. All right, so here is a motion that came out for Mr. Gunn also. This isn't what I want y'all to see. I meant to take this down. So hold on, let me take this down and let me come back over here. There we go. Damn it, that's not what I wanted to do. Hold on, y'all. Let me go back in my bag. Let me see. Hold on. That was not what I wanted to do. Let me do it this way. Where are you? Hold on. Let's pull. Let me see. Don't be trial. No, doggone it. Hold on. Let me pull this up right quick, y'all. So, what's going on? All right, nice. How's things going, man? How you been doing your thing? Okay. All right, nice.
Oh, he's on mute.
Okay, he's on mute. Okay. All right, let me go over here. And let me pull this up. Boom. Go on the file. Here we go. What you do over the weekend? Tang, anything fun? Anything special?
Not too much. The baby got a big girl bed this weekend.
Oh, really?
Yep. So we did that move.
Well, that's a good thing.
Yeah, and then the boy, he's doing good in school, sophomore year. So it's a tough one.
Wow.
But yeah, I lead the boring life.
Oh man, I'm gonna call you Super Mom. Super Mom. Here's what I want y'all to see. Here we go. I found it. Yay. All right. So this here is a. Let me see if y'all can see this. Let me share. All right. Here we go. So this looks like it was a response to a motion that he put in. This here says it's the United States versus Christopher Gunn. Dear Judge Gonzalez, the government respectfully submits. This was put out, y'all, on September 16th. So this was, a few days ago. Okay. It says, Dear Judge Gonzalez, the government respectfully submits this letter in response to the defendant Christopher Gunn's September 13, 2022 motion in which he seeks to modify the protective order entering on August 19th of 2022. The protective order. See ECF docket number 22. The defendant in essence challenges the government's designation of a video as protected discovery, as that term is defined in the protective order. The government designated CG00091 as protected discovery due to the witness safety and privacy concerns that exist in the case. Defense counsel's letter indicates that the contents of CG00091 are publicly available on YouTube. The government has reviewed the information in the public domain and confirmed that as of the date of this response, the contents of CG00091 is publicly available online. Notably, the protective order does not, by its terms, cover information that is or becomes. Defense counsel's letter indicated that the defendant, who currently does not have access to the internet, see ECF docket number 15, has not yet seen the video See ECF docket number 22. Notably, on or about July 6th, the defendant narrated a YouTube live video where he reshared portions of the then available video with the contents of CG000091. The defendant's YouTube live has since been designated as a private video on the defendant's YouTube profile. Part of the public domain, see ECF docket 28 and 9. Therefore, the government does not oppose removing the protected material designation from CG00091. Respectfully submitted, Breon Peace. So it sounds like they are going to, I guess, allow him to see the video. Do I got that right?
That's what I think it says. Was that so that he can see what a fool he was?
Well, pretty much either that or because,
like.
There was talk that there was a clip that went out and did not show the whole video. And that clip is what they, he says, and others have said that, that they, charged him for was because of a clip and not the whole video. And I guess the government got the whole video and I guess they put it under seal or they put it in private or whatever. And he's saying, hey, I want to see the whole thing, so I guess he thinks that'll help him with his
like
with his
for
case.
context.
I guess so.
All his videos are so mean. I can't even watch him.
Yeah, people got their mixed feelings about the situation, but at the end of the day, you can't keep messing with people's families. When people tell you
that's the thing of it. When you're messing with okay, this is all over a guy who's been convicted of pedophilia, child pornography, all of it, and people are messing with other people's lives.
Mm-hmm. Yeah.
And their well-beings, and they're like, it's just above and beyond.
It is. Kush, blessings everyone from Toronto, Canada. Woohoo! Welcome. All right. Well, Tanya with the T, it looked like me and you rocking out tonight. I'm sure if any other readers want to come in and help us out, then they can. Ike Nice got off of here. Okay. So I don't know. So we'll see.
Maybe he'll come back. Maybe he got kicked off.
Maybe. All right. Well, let's go ahead and get started here. Let me go ahead and take this down here. And let me pull this up. And we're going to actually start at the top of page 3492. That's where we left off. Just let me share this with everyone. Now, everyone, we are reading the remainder of Daryl McDavid's. He is being cross-examined right now by the government. And we are reading the remainder of his testimony. As y'all know, Daryl McDavid and Milton June Brown were able to get off scot clean and avoid obstruction charges. And so we're going to actually see what was said on that doggone stand that was able to get them free. Okay, so we're going to start at the top of 3492. Tanya, you will be Mrs. Apatine, and I guess everybody else until we get some other people that want to come up here.
Sounds good.
All right, so we can go ahead and get started.
The truth is that your efforts with these lawsuits, the ones that you say that you were involved in, they weren't limited. They were just limited to containing and suppressing what Tiffany and Tracy and Nia had to say about the sexual abuse, right?
State that again.
Sure. The truth is that your efforts with these lawsuits to pay them off, to just give them money, to make them go away, that was just about suppressing what these girls had to say about Mr. Kelly and their sexual abuse, right?
You're mistaking my testimony.
It wasn't about getting to the truth of the matter.
I'm sorry. Excuse me? I'm sorry?
You said I was misstating. We are moving on. It wasn't about getting to the truth of the matter, right?
Again, you're misstating my testimony.
It was about protecting your boss and protecting your pocket, right?
No, ma'am. It was not about my pocket.
You said that you hired the A-team.
Did I use A-team?
The All-Stars. The All-Star team. Mr. Jensen, Mr. Margolis.
I don't remember referring to them as All-Stars or the A-team.
They were the top of their field.
That sounds like my testimony.
The best of the best, right?
Yes, ma'am.
And you hired the best of the best to beat the cases, right? Objection to the cases. Objection.
I hired them to do their jobs. I'm sorry. I'm going to stop saying I'm sorry, too. Well,
To beat the...
I don't think that was his testimony. That the beat the cases. He hired the best to represent him, but that's, that will be part of it, I guess.
But Judge, I'm just objecting to the extent that it suggests that a lawsuit that results in a settlement is beating a case. It's just to settle. Your Honor, this is cross-examination. I can ask these questions. He can disagree with me. No.
I know he can, but okay. Well, let's start over again. Ask another question and let's carefully put it so that he can understand it.
Your Honor, so I can't ask that question. Is that what you're saying?
The judge answered it. I agree with his answer.
Your Honor, did you overrule or sustain the objection? I didn't hear.
Go ahead. Repeat. Ask it. Ask the question again. And
So my question was, you hired Jerry Margolis to beat these cases, these lawsuits we've been talking about?
that's not no.
Okay, I'm going to object.
Excuse me? No. Wait. He can answer that. Go ahead and answer it. CJ!
Hi, guys.
Hey, CJ.
Hi.
CJ, thanks for coming in. Can you read Bonjean for me?
Sure.
Thank you. We're actually going to start. Let's start right at line 14 when Bonjean comes in.
Okay, I'm going to object.
Excuse me? No. Wait. He can answer that. Go ahead and answer it. No.
You hired him to protect your boss?
No.
You didn't hire him to protect your boss?
Did you not hear my testimony, ma'am?
Right. My question is, you hired him to protect your boss, right?
No. Okay.
You didn't hire him to protect?
Jerry Margolis?
Yes.
No, ma'am.
Mr. Margolis was hired to oversee Mr. Kelly's. We're just talking about just the lawsuits we were talking about just now, right?
Absolutely not.
Who was hired to deal with those lawsuits?
Mr. Margolis dealt with some of them as far as lawsuits were concerned.
Mm-hmm.
Mr. Jensen handled that for the most part.
Mr. Jensen handled the civil lawsuits with Tracy?
Oh, the early. You're going all over the place and all over the time.
Hey, Atmos, did we not read this already?
I'm trying to think we did read this.
I feel like
already.
we read this already.
Where did we stop at?
That I don't have an answer for. But
Hold on, because last time I looked at the. Hold on.
I thought it was me,
I thought
but I
it
thought it was
was
just me because
34.92.
sometimes I dream,
Hold
a
on.
dream about the R. Kelly case.
Yeah, hold on. I was reading this like, damn, this sounds familiar.
Mm-hmm.
Hold on, y'all.
Is anybody in the chat saying that?
Did anybody know where we stopped at last time? Maybe not. Let me look. Let me look at the last video. I think it was video number
I was just gonna say that.
Anybody know what we
34. Oh, here it is. Hold on. Hold on. Here it is. We stopped at. Hold on. Oh, so we finished. Hold on. That was 35, 55.
Oh, wow.
Hold on. It was 35, 55. Hold on. I think we're on a whole different day, y'all.
Good call, CJ.
Damn. Yeah, thank you, CJ. Sheesh. Y'all, hold on. Let me.
35, 55.
Hold on. Good catch. CJ, how was your weekend?
Good, quiet, and uneventful. And that's what you
Hey,
Quiet
CJ.
and uneventful. Okay.
You know what I mean?
My favorite kind.
Right?
Mm-hmm.
Indeed. All right, y'all. Let me see. So, Josh. Yeah, I was reading that like, damn, this sounds familiar.
I remembered from his sassy attitude. Did you hear my testimony? Man, shut up.
Right. So okay, so that was number 9. Let me see. What is this? This was, let's see. So this is the 12th, I believe. Hold on. Oh, no, that's not it. Okay, inbox. Hold on. Josh. All right, hold on. So we had that was the 13th and 14th. We didn't do that one. So that's the 9th. Was it the 12th? Did we get one for the 12th?
I feel like it was a Monday that we were on. I think in the middle of our, or did we get to the bottom of this one and then you were going to stop?
Yeah, it was.
I think we finished to the end.
Yeah, I think no. When I looked at the thing, it showed that hold on. Oh, it was like down to the end. Like, let me go to 55. Hold on. I think you're right.
It was like an odd time.
Yeah. So it was. Let me see. 35, 55. Yeah, 35, 55. Yeah. Okay, hold on. 35. Yep. You're right. Hold on. Here we go. Yep. It was 35, 55 because it was like a weird time they was going into the afternoon session. There we go. Okay, I got it. There we go. Yay. Okay. So we're going to start right here at the top of 3557. Let me share this with y'all. Let me stop sharing. And now let me share. Hold on. Let me take this down. Take this down.
CJ, what kind of dog is that?
It's a Cavapoo. It's a mix between a Spaniel and a Poodle.
Yeah,
it's called Cavapoo.
Uh-huh.
I was thinking about getting that next. I have a Shih Tzu.
They have mixtures of those too.
Yeah, but I really like the Cavapoo.
Yeah, I got this one because it matches your like energy level. So it's just like if I want to go hiking, she's down, and if we don't move anywhere, like this weekend, she's down.
Yep.
All right.
Dog too.
I think we good, y'all. So at the top of this here is Miss Pozzolo. Pozzolo, I'm sorry. So if you want to, Tanya, still read Pozzolo, you can still stay the government. And if you could be Miss Bonjean or Miss Judge, CJ. Mr. Brindley, you could be Mr. Brindley. Nice if you're still here.
Okay.
And then we'll go back and forth between with McDavid. Okay, so we'll start at the top of 3557, line 2, please.
We have one thing to address with the court.
Yes.
We are going to make the request that the individuals at McDavid's counsel table stop gesturing yes and no to him when he looks over during the questioning.
You got to be kidding me.
No, I'm not kidding. Unfortunately, I'm not. And I wish I was. But our case agent is seeing this behavior happening. And we're going to ask that it stop for the rest of his examination.
Well, since it didn't happen in the first place.
If it didn't happen, it didn't happen. It won't continue to happen.
Absolutely.
Let's get the jury in. They're out in the hall. Proceedings heard in open court. Jury in. Please be seated. Miss Appertine, you may continue your cross-examination.
Thank you, Your Honor.
Daryl Marcus McDavid, defendant McDavid's witness, previously sworn cross-examination resumed.
Mr. McDavid, you testified that you entered into a formal agreement with Mr. Kelly's lawyers regarding his 2008 case, the 2008 trial. Is that right?
Yes, ma'am.
And was that a formal written agreement or just oral agreement?
No, it was a written agreement.
As part of the legal team, did you attend pretrial hearings?
Yes, ma'am. You
were present when the federal and state immunity was conferred on Lisa Van Allen at a pretrial hearing, weren't you?
No, not that I can recall.
As part of the legal team, you knew that she had been immunized by federal and state authorities prior to her testimony. Is that right?
No.
Now, for the trial itself, and again, we are talking about Mr. Kelly's 2008 trial.
Yes, ma'am.
You testified that you saw snippets of a tape before the state trial. Is that right?
That's correct.
You did not see the entire tape prior to the trial. Is that correct?
No, ma'am.
Now, you talked in your testimony about believing that there was a fake tape at the trial. Is that right?
Yes, ma'am.
Did you watch the entire tape at trial?
No, ma'am. No, ma'am.
Are you aware that the entire video was shown at that trial?
Yes, ma'am.
And you were not in the room? You were not in the room when that video was shown. Is that your testimony?
No, ma'am. I was in the room.
You were in the room.
Yes.
You chose not to watch the video.
Yes, ma'am.
Now, you said that you saw, just to be clear, you saw none of the video at the state trial during the trial itself. None of it.
I glanced back and forth a couple of times. I do remember the part about the back, and I did look at that part.
You saw that during the trial.
Yes, ma'am.
And so you're saying, did you see a female at all in the video?
I glanced back and forth. Yes, there was a female in that tape.
So you saw the person's face that was a female in the tape.
I don't recall.
What part of the female did you see?
That was a body, a female body.
You saw only a man's back. Is that right?
Objection. That mistakes his testimony.
Overruled. He can answer. I didn't hear the.
My question was, you saw only a man's back. Is that right?
No, ma'am.
What did you see
As
of the man?
Ma'am, I watched the entire part about the back a couple of times. I glanced over while the tape was playing. A couple of times I glanced over while the tape was playing.
And it appeared to be Kelly to you, correct?
Yes, ma'am.
Did you see the part? Did you see the part in the video with the necklace? The necklace that you had been speaking with Mr. Jensen about?
I don't recall. I don't believe so.
Did you see any? You said that you glanced at it. Did you see any of the two individuals? Did you see any parts where the two individuals were engaged in what appeared to be sexual conduct?
I don't recall.
Now, I believe it was yesterday you testified about how your thoughts during the trial were that the trial was won. Is that correct?
Say that my thoughts about the trial. The trial was won.
Yes. During the trial, you came to the conclusion at some point during the trial, whether it was from your conversations with the lawyers or your own observations at the trial, that the trial was won.
Yes, ma'am.
Okay. And you knew that the trial was won because Jane wasn't going to testify, right?
No, ma'am.
You knew Jane wasn't going to testify, right?
Yes.
Do you recall you testified about conversations with Mr. Jensen saying that he didn't want her to testify because she would be subject to cross-examination? Do you remember that?
Yes, ma'am.
And he didn't want her to be subject to... Did you want her to be subject to cross-examination?
No, ma'am.
And that's because if she was, that the truth could possibly come out.
Objection. Sorry.
Objection sustained. It's argumentative.
Now, the trial lasted from about the beginning of May to the first week in June. Is that your recollection?
That sounds about right, ma'am.
Thank you. You testified yesterday about where the criminal courthouse was, right?
Yes, ma'am.
And you testified yesterday that you were there most days of the trial. Is that right?
Yes, ma'am.
You were there when the verdict was read.
Yes, ma'am.
Okay, I'm showing you what has been marked as Government's Exhibit 125. It's just for the witness. Do you recognize the photo?
No. I mean, I know who the people in the photo are.
Who are the people depicted in the photo?
Mr. Brown, myself, and Mr. Kelly.
And is there anything that's written on the building right here that indicates where this photo was taken?
Yes.
Where?
Cook County Criminal Courts Administration.
And you testified yesterday that the only criminal case that you were aware of Mr. Kelly's was the 2008 criminal trial. Is that right?
Objection, Judge.
Objection. Yes.
Objection sustained.
So you were asked questions yesterday from 2001 to 2008. What criminal trials of Mr. Kelly's you were aware of? Is that right?
No. Objection. Misstates the question and the testimony.
He can correct it. Overruled. I don't. Wait. Answer? You may answer, but you don't. If it misstates your testimony, you're entitled to correct it. Would you please?
Yes. From 2001 to 2008, during that time period, were you aware of any investigations that Mr. Kelly was involved in?
Yes.
And which cases, which investigation?
I'm going to object, Judge.
Who object?
Your Honor, may we have a sidebar?
Proceedings heard at sidebar. As you see, they had a little short sidebar. We come back into court. Proceed.
Thank you, Your Honor. Now, do you recognize this photo as being taken during the pendency of Mr. Kelly's 2008 trial?
No, ma'am.
Do you recognize it as being a picture taken during the pendency of Mr. Kelly's 2002 case?
I don't.
Objection. This is misleading. It is.
The charges were in 2002, but the trial was not until 2008. So during that 6-year period, does this appear to be a picture taken outside of the Cook County Criminal Courts building that you attended?
Hold on, I'm go ahead and jump on the stand.
Me?
Yes, please.
Where we at? What number?
12.
12. That you attended. I can't say where this picture was. I remember this picture. I don't remember this picture.
My question was, does it appear to be a picture taken outside the Cook County Criminal Courts Administration courthouse during the time period 2002 and 2000? Oh, can you go back down? 2002 and 2006, when Mr. Kelly's case was pending.
Well, that's what the sign says. So based on what the sign says, I would have to assume that that's correct.
Your Honor, the government moves to admit Government's Exhibit 125.
Your Honor.
Oh.
Yeah, you understand. Thank you, man. Yeah, I'm sorry. I had a phone call. I got a little confused with that. I had to answer that call. Your Honor, we would object to improper foundation. The witness says that he doesn't know when the picture was taken, and he's just reading comments on the picture to try to orient it in the lease. Go ahead and read Miss Leon to tell you.
Brown objects on relevance, Your Honor.
I'll let it in.
Judge, I would object because it's cropped and it doesn't show the entirety of the picture. There's someone else's hands in there that we don't know who they belong to.
I don't know if it's cropped or not.
Yes, there's another person, Judge, all the way to the right. So it gives the impression that...
All right, I'll refuse it.
Your Honor, the picture is for... I can't have him identify other people that are in it that he does not know. And so he's only identifying...
We don't know when it was taken. We know where and what the circumstances were, so I don't see the relevance.
Your Honor.
Objection sustained.
Thank you.
Let's move on.
So we are still talking about the trial time period. So 2008.
Yes, ma'am.
Do you recall giving testimony talking about Chuck Freeman and a press conference that he said that he was going to hold? Do you recall giving testimony about that?
During this trial?
Yes.
Yes, ma'am.
And you paid Mr. Freeman because you didn't want him to come forward with any tapes. Is that right?
No, ma'am.
You paid Mr. Freeman because you didn't want him to come forward with any information related to Mr. Kelly. Is that right?
Yes, ma'am.
At the time that you paid him, you didn't know that he still had tapes containing or depicting Mr. Kelly, did you?
Objection assumes facts not in evidence. Nobody knows that at this point.
Join that objection.
Your Honor, Mr. Freeman testified that he had tapes. The tapes that are the subject of this trial, videos 2 and 3.
But there's no...
And that have admitted into evidence.
I don't mean to... He can answer.
The question was, did you know at the time that you paid Charles Freeman that he still had sex tapes depicting Mr. Kelly?
No, ma'am.
Now, in 2009, you testified about, not in 2009, your testimony yesterday was, well, it covered the 2009 lawsuit that Mr. Freeman filed against Mr. Kelly.
Is that a question?
Yes.
Yes, ma'am.
And at the time, after that trial, you said, you testified that there was going to be no further money given to Mr. Freeman. Is that right?
Yes, ma'am.
And at that time, did you know that Freeman still had copies of tapes depicting Mr. Kelly?
No, ma'am.
Objection assumes facts not in evidence. Well, I think she states it as a fact. The more question would be that Mr. Freeman has contended that he had tapes. I think he testified that he had them. Well, that's what he said, all right? So, but I don't think it's been proven that he had them. But you can answer the question.
What was the question?
The question was, at the time you paid Mr. Freeman that settlement back in 2009 lawsuit, did you know that he still had copies of tapes depicting Mr. Kelly?
No, ma'am.
All right. Mr. McDavid, we're going to move forward in time to 2014.
Yes, ma'am.
I want to show you Government's Exhibit 337 that you went over. Your Honor, we can publish to the jury. It's already in evidence. Government's Exhibit 337. Okay. So you went through in your testimony the basis in detail for this $1.3 million that you were owed. You went through that in detail with your lawyer yesterday in your testimony. Is that right?
Well, to the extent I was allowed to, yes.
Now, this settlement agreed that you discussed yesterday. Now this settlement agreement also contained a confidentiality provision that you discussed yesterday as well, correct? And
Yes,
I'll
ma'am.
just point you to it. It's here. 13.
Yes, ma'am.
Do you recall going over that with your lawyer yesterday?
Yes, ma'am.
This confidentiality provision, you were the only person in this, well, that's named in this confidentiality provision. That is the person that's to keep strictly confidential all knowledge about Mr. Kelly, right?
Well, I'd have to read the whole document, but I would assume yes.
This sentence right here says that Mr. McDavid further agrees to keep strictly confidential all knowledge and information, either personal or professional, regarding R. Kelly, bass, touring, and publishing. Is that right?
Yes, ma'am.
Mr. Kelly is not prohibited from keeping strictly confidential anything about you, right?
Well, based on that paragraph, no.
You mentioned that that's not in this paragraph. Did you need to read the rest of the agreement to determine whether or not Mr. Kelly is bound to keep things about you strictly confidential?
Well, I mean, in the sake of time, if you say that that's the only place that it says it, I'll take your word for it.
No. My question was, is Mr. Kelly bound to keep your information about you strictly confidential?
I don't.
That is my question.
I don't know. I don't know.
You don't know if it says it anywhere in this agreement?
No, if it says it doesn't,
No. My question is, do you know?
no, ma'am.
Just one moment, Your Honor. Now, Mr. Freeman, excuse me, not Mr. Freeman, Mr. McDavid.
Yes, ma'am.
According to your testimony over the last 2 days and today as well, it's your testimony that you were not in Kansas City viewing a video that Charles Freeman turned over, right?
Yes, ma'am. That is my testimony. I was not in Kansas City.
And you weren't at the hotel meeting with Jane when her parents met. Jane and her parents met with Mr. Kelly, right?
Oh, no, ma'am.
And you didn't view a threesome tape with Charles Freeman in Mr. Kelly's house, did you?
Absolutely not.
And you were not in the room when Lisa Van Allen watched the threesome tape in Chicago.
I'm not. I never. I mean, well, no, ma'am. You're kind of confusing me with there because I didn't know what you.
Were you ever in a room with Lisa Van Allen watching a threesome tape?
No, ma'am.
Were you ever in a room with Mr. Jensen watching the tape that you received from Keith Morrell?
No, ma'am.
And it's your testimony that you did not give Mr. Freeman the $100,000 during the state trial when he threatened the press conference, right?
You mind repeating the question, please?
So you weren't there when Mr. Freeman was paid the $100,000 during the middle of the state trial when he threatened to the press conference?
Oh, no, ma'am.
You had sent a messenger, I believe you said, right?
Yes, ma'am.
So, Mr. McDavid, you removed yourself from every situation where a witness has said you had knowledge of what was going on with the sex tapes with Kelly and Jane. Is that right?
Objection, Your Honor.
Now you know.
Objection. That's argumentative.
And your testimony is that before this trial, you never saw videos 1, 2, or 3. Is that right?
Well, there was a whole court thing with video 1. It's video 1, the video from 2008 case?
My question was, you never saw this trial, what we're referring to at this trial as video 1, video 2, or video 3.
Which one is video 1? I didn't see video 2 or 3. Which one is video 1?
The video that we watched in this courtroom.
No, I never saw that entire video. No, I was it was the snippets from the back.
And it's your testimony that you've never seen the video that we've been referring to this trial as video 4, the threesome tape with Lisa Van Allen, Mr. Kelly, and Jane.
No, ma'am. I've never seen anything like that.
Just a moment, Your Honor. Nothing further, Your Honor.
Cross, Miss Bongino, I'll give you the opportunity.
I have about 5 questions.
Pardon?
I have about 5 questions or so, if it's okay.
All right.
Thank you.
Proceed.
Mr. McDavid, I just have a couple questions based on what the prosecutor has elicited. Do you remember the line of questioning earlier today about lawsuits, the cookie cutter lawsuit line of questioning that the U.S. attorney was asking you about?
Yes, ma'am.
Okay. I believe you testified that after Asti Watkins situations, you sort of delegated that to a team of lawyers. Am I right?
Yes, ma'am.
You weren't studying the lawsuits, I assume. You were. You were letting the lawyers handle lawsuits, correct?
Yes, ma'am.
So the allegations in those lawsuits, as you sit here today, I'm guessing you don't know the specific allegations in those lawsuits, right?
No, ma'am.
You don't know how many lawsuits were filed, I assume, as you sit here today, right?
Oh, no, ma'am.
And I think your testimony was that there were, your sense was that they were kind of cookie cutters. But as you sit here today, you can't tell us anything about specific allegations in those lawsuits, right?
No, ma'am.
You heard testimony from a number of other individuals in the courtroom, as we all did, not just Jane, but these other women. I think Nia, I'm trying to get the Tracy, and then there was, what's the third one?
Pauline.
I just want to get to the names. You have no firsthand knowledge about their allegations, correct?
Oh, no, ma'am.
Now, as you sit here today, you have no idea how Chuck Freeman got those tapes 2 and 3, right?
No, ma'am.
You have no idea whether he's even had them for at least 20 years, as he claims, correct? For the last 20 years, as he claims, correct?
Oh, no, ma'am.
Doesn't it seem odd that Mr. Freeman had a tape he would just hold on to for 20 years?
Objection, Your Honor.
Yes, ma'am.
Objection, Your Honor.
Objection.
My understanding as to the scope of the recross was about Your Honor's ruling.
Well, it's supposed to be limited to any new matters brought up.
Which?
During the cross.
Your Honor, may we have a sidebar, please?
Proceedings at sidebar. That was short.
Do you guys notice how when his attorneys object or anyone on the defense object, he continues to answer the question, but then when the prosecution objects, he's just like, "Oh, should I answer that?" I'm like,
right?
Exactly. Playing, boy.
He's smart because he knows.
Yeah, he was well prepped. I'm just saying, it really burns my britches.
Seriously, definitely.
Anyways, and Mr. McDavid, you were unable to say, as we sit here today, whether tape 1, as the government calls it, is the same tape that was used in the 2008 prosecution, right?
Objection. Argumentative.
Ooh, Alexa.
Judgment in Twilight Zone.
What's happening? Hello?
He's going down with the ship, y'all.
We're going to lose Atmos.
Oh.
And lose his scrolling abilities.
I know.
Because I don't have this.
A little bit.
Really bad, poor connection.
Okay.
Why don't you try to spin the block real quick? Go out, and come back in.
Hold on.
Please ask me that again, Miss Bonji. Please. Yeah, this cat, he's very well prepped. Tanya, you there? CJ, you there?
Yeah, I'm here.
What Tanya at? She there?
I'm here. Can you hear me?
Okay, yeah. Not really.
Oh, Atmos.
Is that bad?
Yeah, it sounds like it sounds like you got a bad connection.
How about that?
Can't even see your avatar.
Mm-hmm. And I was here, Mike. I was doing something for my dog.
The avatar back
Oh,
up.
you're back a little bit, but you're frozen.
I'm frozen.
Mhm.
There you go. It sounded better now. No, but she's right. You frozen. I mean, is you moving? Yeah, it's a live avatar.
Why don't you try to turn off your
You
video?
you on Wi-Fi? Oh, you get on the Wi-Fi instead of your phone. I don't know if you're on his phone or your computer.
It's still bad.
Yes, it's bad.
Hold on. Let me do this. I'll come back.
That don't normally happen to him, do it?
Where's Riri been? I heard that she was on vacation, but
Is that where she is? Because I haven't heard from her in a while.
I remember that's what Atman said of hers.
My sister got married. Nope.
No sirree, Bob.
Sound like you in the Matrix. You still in the Matrix.
Mm-mm.
Try to turn off your video, Atmos. Sometimes it can't do too many things at once if you just put your regular avatar there.
Is that better?
Keep talking. Let's see.
Yeah, it still hasn't caught up on our side. I still see your frozen.
Yeah, I still see your frozen thing.
Mhm.
Frozen.
You trapped in the Matrix.
Pretty.
You have to get what's the dude name? Neo. Neo. Yeah, gotta get Neo to come get
Keanu.
you.
Keanu Reeves.
Yeah, Neo, Keanu to come get him out of the Matrix. Go out and come back in one
Oh,
more.
he's out.
He's out now. Go out again. If you don't see. Oh yeah, I was saying my sister got married this weekend,
Oh,
Saturday.
congratulations.
Oh, congratulations.
Is that better?
That's much better.
Yay.
Great.
Good grief. I don't know what the hell happened. Sorry, y'all.
Yeah, we was
All
like the judge. Somebody put something on the judge.
Man, let me pull this. Let me pull it back up. Y'all remember what page we was on?
Uh-oh.
Okay, don't worry about it.
Turn off your video, Atmos. Turn off your video. Your like personal video.
Okay. How about that?
That's a little better. Still poor though.
I don't understand. Oh. Somebody don't want us to read these things.
Oh my God. It didn't matter the Matrix. 5 minutes.
Where was the wedding, Mike?
In Augusta.
Indoor, outdoor.
Indoor. Yeah, it was indoor.
Nice.
At this
Am I still sounding crazy, y'all?
a little crazy, but it's a little better crazy.
Yeah. Just enough crazy for us to give you the side eye, but not like walk across the street.
Yeah.
Oh gosh. Let me see. Hold on.
It sound like you sound like what's that rapper name that they always use the auto tune?
T-Pain?
No, Future.
Oh, Future.
Oh my gosh. Is that bad?
Yeah. It sound like Future, bro.
Oh my gosh, y'all. I'm sorry. Hold on. So let me rewind. Rewind.
You can understand T-Pain, but the Future.
Hold on. Wait. Hear me now?
No, you were back before.
It's still, I was better the other way.
Oh,
Okay.
this is
Okay. That's
good.
coming together.
That's better.
Yeah.
Yeah, we picking up what you putting
Okay.
down now.
I just got to go through the actual thing instead of through that mic, I guess.
Oh,
Okay. So I know we was at 30, 35, 55.
Number 6.
So let's see. Both is popped out of 9. Okay. So hold on. Let me share this with y'all. Let me share. So, okay. Y'all see the transcript?
Nope. Oh, wait, yeah.
mm-hmm.
Okay, hold on. 1.3 million. Answer the question. Well, that's not what I said. I don't think it's been proved. Hold on. Brindley, she states that it's fact. Okay, we went past that point already. Sake of time. Excuse me, not Mr. Freeman. Okay. Video 1, 2, and 3. Studying lawsuits, I assume. I think it's your testimony. You were there. No, ma'am. Pauline. I think we're getting close. Okay. I think we stopped right up in here.
Yeah, number 6 on whatever page you said.
Number 6. Okay.
Yeah.
Overruled. If he knows, it's a cross-examination.
Please ask me again. Please ask me that again.
I said you don't know whether the tape that has been introduced or the video that has been introduced in this case that is being called tape 1 is the same video that was introduced at the 2008 prosecution.
I have no way of knowing that. No.
And one final question. You were just asked a question about the confidentiality agreement and whether or not Mr. Kelly was prohibited from revealing your personal information about you, right?
Yes, ma'am.
Were you a celebrity?
Unfortunately not, no.
And in your experience, is it uncommon for celebrities to want to keep their personal information personal?
Yes, yes, ma'am.
Do people sometimes like to trade on celebrities' personal information?
Absolutely.
1 second, Judge. We're good. Thank you, Judge.
Mr. Brindley, any redirect? I have a few questions, Judge. All right, a few? Yes. Everybody gets up and says, I have 1 or 2 or 4 questions, and then about a half an hour later. Well, I didn't say 1 or 2 or 4. I said a few. I didn't say whether it was a few hundred or a few thousand. Mr. McDavid, can you hear me pretty good?
Perfect.
Yes.
Mr. McDavid, going back to the cross-examination by the government, let's just get one thing straight from the onset. Now, she kept asking you questions, saying things like, well, you were trying to hide child pornography, or you knew about child pornography on some tape. Outside of her saying those words out of her mouth, when, if at any time, did you have any knowledge of any, really, child pornography back in 2000 and 2008 at the end of the trial that we've been talking about?
Repeat the question.
Yes. When, if at any time, did you ever have any knowledge about Mr. Kelly actually being in any child pornography between 2000 and 2008?
There was one accusation.
Okay. And setting aside the accusations, I'm asking about actually being on a tape. Like, I don't think you're following me.
Okay.
My question is, between 2000 and 2008, was there ever a time that you actually knew about Kelly really being on any sort of child pornography tape?
Oh, no.
That you could see?
No, sir. No, sir.
Okay. So when she's sitting here making all these grandiose say, what is that? What is that?
Grandiose.
What's that?
Grandiose.
Grandiose statements about how you knew it was child pornography and you were trying to hide these tapes with child pornography. Was there any truth to that?
Absolutely not, sir.
Okay, so that's just a bunch of things that they like to say. Am I right?
Objection, Your Honor. Argumentative.
It's sustained.
It
It
is.
is?
Oh, it is. Yeah, well.
It is. Were you asked a question by the government at the beginning about the fact that you made money doing or working for R. Kelly? So let's get to it. Did you make some good money working for R. Kelly?
Yes, I did.
Okay. And did you make, several $1 million working for R. Kelly?
Yes, I did.
Okay. And based on all the effort that you had to go through to deal with Mr. Kelly over those years, don't you think you earned it?
Probably a little bit more. Yeah, yes, I did.
Okay. Well, hold on. Okay, yes, I did. Okay, so yes, of course, you made a lot of money working for R. Kelly, but Mr. McDavid, they were trying to suggest that you made $1.6 million in 2006. And then you said, no, that's definitely not right. Can you explain why they were wrong?
Well, I think she summed up the number itself. It was like $700,000. I don't recall.
Okay, so when she said it was 1.6, and that just wasn't true. Fair?
No.
Okay. And ultimately, can you explain the different kinds of, because there was like some confusion.
Yes.
All right. No, let me get to the point of it. There was a confusion about like what amounts of income and what amounts to payments. Do you remember that?
Yes, I do.
The discrepancy. Okay, so what kind of payments did you get in addition to your 10% commissions?
Well, from various times I loaned him money. The biggest thing would have been American Express bill. Rob didn't have a credit card, so various members of his entourage had credit cards on that account. And the relationship was that they could use the credit card because you had to have a credit card for hotels, for flights, and things of that nature. So Mr. Kelly used that credit card through his staff and sometimes through me to make charges on the credit card. At the highest balance in the month, I believe it was 1.5 million. That was a little bit earlier than the time we're talking about, but there were all sorts of monies that came back to me from various things that either it was logistically not possible to pay with his money or credit card payments, which were extremely substantially, and things I can't remember.
Okay. But so all the payments that you received, was all of that actually income?
Oh, no.
Okay. Nonetheless, the fact that you made a whole lot of money, millions of dollars working for Mr. Kelly, who was your biggest client, would that be justification for you to be involved with child pornography, sir?
No.
The government referenced the amount of money in settlement agreement and talked to you about how it was calculated. And it was the amount, I think you remember it now. Let me read it. $1,300,000 $361,528.20. Now, you remember yesterday we were talking about that amount, and we talked about the touring. Was there some confusion following the objection about, all the things that went into that 1.3?
Absolutely.
Okay, so can you just clarify it and make sure that it's clear to everybody that we were all the things that went into the calculation of the $1,361,528.20?
Yes. Commissions that were due me from publishing, commissions that were due from me from production, loans, credit card payments. It was all broken down because I can't remember everything at this point, but it was all broken down, obviously, to the 20 cents.
Okay. So every dime was either for a loan or loans. Not a lot of money. I mean, but for commissions, loans, American Express cards, Visa cards, that type of thing. That was your part.
Yeah.
Go ahead, read that.
Every dime was either a loans, not not a lot of money, but for commissions, loans, American Express cards, Visa cards, that type of thing.
Okay, and so then we just talked yesterday about a big number with respect to touring, but it was a lot more than that. I mean, that actually went into the calculation. Am I right?
Exactly. That's what. Yes.
Okay, now the government lawyer kept saying to you things like, well, you didn't believe the girls just because they were asking for money. And you said, I can't agree with that. Or, you were uncomfortable saying yes to those questions. Do you remember that?
Yes, sir.
Y'all, hold on. Let me see who this QT is. Hold on. Hello? QT? Okay, they got off. Okay. Go ahead. You say yes, sir? All right, nice.
Yes, sir. I said absolutely.
Okay. So first of all, she asked about Tiffany Hawkins and your reason for disbelieving Tiffany Hawkins in the end. What was the most substantial reason for which you disbelieved just her, starting with her?
Because she went from $10 million to $250,000.
And what you saw in the deposition of Tiffany Hawkins with your own eyes after that, did you have any doubt that she was lying?
It was 7 hours of lies.
Wow. Okay. Did it look similar to the questioning of Chuck Freeman when I questioned him here in this court?
It was worse.
So having seen with your own eyes that Tiffany Hawkins was lying, after that, just to be clear, because they kept saying to you, it was just girls asking for money. You just wouldn't believe any of them. I want to correct that. After Tiffany Hawkins, that you knew that she was lying because you saw it with your own eyes after her. Did you find out that Tiffany Hawkins was introduced to the lawyer by a particular person? Do you remember who that was?
Demetrius Smith.
Okay. And counsel for the government asked you about the Austin Watkins situation. Well, let's get to it. The Austin Watkins situation in 2001, in January 2001, you learned of the interviews by Jack Palladino and Austin Watkins. At that time, what had you found out that Demetrius Smith was doing vis-a-vis underage sex claims against Robert Kelly?
Well, his and Barry Hankerson were offering people to lie and make up those statements.
Offering them what?
Money.
And when Mr. Palladino bought you or provided to Margolis, who provided to you an interview report of Miss Watkins telling him these things? Did you have some reason to believe that Jack Palladino was lying? So,
I'm sorry. Was there an answer?
I don't know if that was you or me.
I think it was you. What was the answer to the question? Did you have a reason to believe that Jack was lying about what Asti said?
No.
Okay, so at that point in time, then, after you've seen what Hawkins is lying with your own eyes, now you see Demetrius Smith is the person who introduced him or her to Susan Loggins. He's the same guy that's paying people to lie about Kelly and make up these underage sex claims. Is that right?
Yes, sir.
Okay. And the other settlements that they're talking about, they talked about the Tracy settlement in 2002. They talked about the Nia settlement. Both of those settlements. Is it correct to say both of those settlements happened after you'd seen the Hawkins deposition and knew about Asti Watkins?
Yes, sir.
Okay. K-Love 92.
Hey, everybody.
What's
How
up,
are you?
I'm so sorry
Lovely.
I'm late.
The working
You
girl?
good.
How
Oh
you
my
do?
God,
Good.
yes.
Thanks for coming in.
I put my notice in though. My last day here is going to be the 1st. I can't wait.
Oh, are you sad?
No,
Yeah.
Were they sad?
absolutely not. But I work the next, I work tomorrow and I work Wednesday, and then I'm off the rest of the week.
Oh, good. You
Oh,
gave
good
yourself
for
a little
you.
breather time. Smart.
Yeah.
Yeah, me and my sister, we're going on a trip. We're going to North Carolina to see my best friend.
Nice.
Isn't that something? You're going to be close to me. I'm over here in Georgia.
Right.
Yep. Okay. Well, we are in here. We will plug you in.
Okay.
Thank you for doing this.
No problem.
Because I think it's about to get real busy in here.
Okay.
All right.
Actually, Caleb, do you mind doing the defense lady parts? I'm gonna get a delivery and my dog's about to
Who
go
is
quick.
that?
Okay.
Boho?
Yeah, yes, ma'am.
Okay. No problem.
Or Miss Judge too.
Okay, got you.
Yep.
Thank you, love.
Perfect. Thank you.
Mm-hmm.
All right, where we at, Mr. McDavid?
You were saying okay, and the lawyer?
Okay, and the lawyer for Jane. I'm sorry, not Jane. Tracy. The lawyer for, you're not the only one that confuses the names. Your lawyer, the lawyer for Tracy, the lawyer for Nia. Was it Susan Loggins?
To the best of my knowledge, yes.
Okay, so the lawyer for both of these people that had the settlements is the same person who was being bought clients by the man who was paying people to lie about underage sex with Robert Kelly. Is that right?
Yes, sir.
And so when you knew all of that, what conclusion could you draw about people that were making claims for money that were being sought by Susan Loggins?
They were false.
So when the government says you just don't believe women who make claims for money, was that true or was that false?
That was a false statement.
There is a dispute with the government counsel because she said that, they kept saying you hired Jerry Margolis to beat the case. And did you hire Jerry Margolis to beat any case?
Absolutely not.
Why did you hire Jerry?
1994.
Yeah, what did you hire him to do?
Well, to be Robert's entertainment lawyer.
Okay. And was this long before Jerry ended up having to deal with Tiffany Hawkins?
Yes, sir.
So then, is there any truth to this notion that you hired Jerry Margolis to be the case?
That notion is false.
And there was this criticism of you, or certainly that was a, connotation that there was a criticism of you that you just listened to or you talked to after you heard about, the Jane allegations in 2000 or December of 2000. You talked to Robert, you talked to Jerry, and then the two of you talked to Robert. And they say, they said that, that's all that you did. And you said, well, yes, that's all I did. Do you remember those questions?
Yes, I do.
Now, if we take it one step aside from what you personally did yourself.
That's what yes.
I know that's what she asked you. I understand. She had her purpose in what she was trying to do. But the truth of the matter is that when we look at the whole picture, you did tell Jerry. You and Jerry did talk to Robert. And then what did Jerry do immediately thereafter?
Well, he hired Jack Palladino to investigate the entire thing.
And then Jack Palladino, she asked you questions about whether you went and interviewed Jane or you went and interviewed Jane's family. Who went and interviewed Jane?
Jack Palladino.
And who went and interviewed Jane's family?
Jack Palladino.
And did he do that in January of 2001, right after you found this stuff out?
Yes, sir.
Okay. And so, did you then get the results of Jack's interview?
Yes.
In the reports that we entered?
Yes, I did.
And in those memorandums, in the interview reports that Jack provided, what did you find out that Jane, Mom, and Dad said to Jack?
Well, nothing ever happened.
Okay. So at this time, did you have some reason to believe Jack Palladino was lying about the interview?
No, absolutely not.
When Robert had denied it, and now an independent investigator has been sent, and he's coming up with the interview results saying there's no truth to it, did you feel that you needed to go out and peep around Robert's house and see what you could come up with?
No, sir.
Did you have any reason to doubt the results of Jack's investigation?
None whatsoever.
Okay. When Jerry responded by having the matter investigated by Jack Palladino, did you believe there was a thorough investigation being done on this?
Well, that's all Jack ever did. Yes.
She said in reference to this contract that Jack had to put together for dealing with Chuck Freeman, she talked about you guys hiring Chuck Freeman to do a job. Do you remember her saying those things?
Yes, sir.
Okay. Mr. McDavid, is it fair to say that the only job Chuck Freeman was doing was turning over a tape that was using to blackmail Robert Kelly?
Yes, sir.
Okay, so did you ever hire him to do any actual work?
Yes, sir.
I'm sorry, go back up. Okay, did you ever hire him to do any actual work?
Yes, sir. Oh, wait.
21.
Wait. You talking about Chuck Freeman?
Yes.
No, sir.
Okay. And they asked you about whether you called the police when you found out that there was a stolen sex tape. that Chuck Freeman was threatening to give to the press. That, you know, at that time, was anybody suggesting that Chuck's tape had any underage on it?
Are you talking about the press conference?
No. I'm talking about in August of 2001, when Chuck had the tape that they were going to.
Oh, no, sir.
Okay. So in August of 2001, with respect to this tape, I mean, did you think that Mr. Kelly was going to be comfortable with you going to the police to talk about a private sex tape that he didn't want getting out to the press?
Hey, love.
Oh, I'm sorry. I thought I was Bonjean. Objection, speculation.
Hold on, where is CJ here?
She said
CJ,
she had
you
to deliver
Bonjean,
it or
right?
something. She told me to do
Oh.
it because she had something coming.
Oh, is Tanya still here? Tanya, you sleep yet?
It's fine. I got it. It's fine.
Oh, okay. Okay, all right.
Objection,
Okay.
speculation.
Okay, hold on. Objection, speculation. Overruled. He can answer.
I know the answer, but ask me the question again.
The question is this. This was a private sex tape that Mr. Margolis wanted to prevent from getting into the media. Is that right?
Yes.
Okay, so did you think that under those circumstances, did you think Mr. Kelly would be comfortable with you going and broadcasting that to the police?
Absolutely not.
And ultimately, who was the one that gave the directions about how this sex tape scandal could be handled?
That was Jerry Margolis and Jack Palladino.
And Jerry Margolis and Jack Palladino were combined experience with sex tapes for superstars. Mr. McDavid, what was your understanding of what that experience was?
Extensive.
Okay, so when they didn't suggest that you should go to the police under these circumstances, you wanted to prevent a tape from getting to the media. Did you have a basis on which to think that they were wrong?
No.
There was a suggestion that Jack Palladino, or a couple of different suggestions, but not that they were all consistent even, but let's start with this one. There was a suggestion that Jack Palladino had watched this video and that there was some notion that Jane was on it. First of all, Mr. McDavid, in August of 2001, that was after the January 2001 interviews of Jane done by Jack Palladino. Is that right?
Yes, sir.
So when Jack Palladino got the video and saw it, he had already met and seen Jane. Is that true?
Yes, sir.
Okay. And when if at any time after viewing this Chuck Freeman tape, did Jack Palladino suggest to you or Jerry Margolis any information you have that the girl that he saw on the Freeman tape was the same girl he interviewed in January of 01?
Never.
When if at any time that Jack Palladino indicate to you or Jerry Margolis indicate to you that there was any indication of an underage person on that tape?
Never.
In August of 2001, when you're claiming, or when they're claiming, the government claims, based on their questions, that Mr. Palladino has a tape of an underage person engaging in sexual intercourse with Mr. Kelly. After the conversations with Jack Palladino and Jerry Margolis in August of 2001, how many criminal lawyers did you talk to?
None.
You've indicated that Jack and Jerry were the best in the business, and that I think that this was to Miss Bonjean's question, but you indicated that their careers, Robert Kelly was sort of a drop in the bucket compared to the people that these guys were dealing with and they had to deal with. Do you remember that?
Yes, sir.
Okay. So, Mr. McDavid, based on your personal experience over years,
Yes.
with both Jerry Margolis and Jack Palladino, what, if any, reason? Well, let me just put it to you this way. Do you think, based on your personal observations of these men and your knowledge of who they were and what they had done, did you think that either one of them would be willing to hide child pornography for Robert Kelly?
Objection. Argumentative.
Objection sustained. That's pretty much final argument. Fair enough.
Don't answer.
No.
Guys, CJ's back whenever you need me.
Okay.
I got delivery.
Thanks, CJ. Okay. Government counsel suggested to you, questioned you about whether or not a couple of things. Let me rephrase that. That was a mess. Government counsel questioned you about some things on Jack's billing statement. Do you remember that?
Yes.
Okay. And one of the things that they were questioning you about is whether or not 12 a.m. or to 2 a.m. phone call on the, well, let me put it to you differently. One of the things they asked you about was whether or not your phone call that night with Jack was on the billing statement. Do you remember that?
Yes.
Okay. And a specific phone call with you, McDavid, with your name that was not listed that night. Is that correct?
Yes, sir.
Okay, now there was a billing statement, August 24th of 2001, 12 o'clock to 2 o'clock a.m. Telephone conferences, multiple conferences with client. Now, when it says client in this, do you have an understanding of whether this was you or Jerry or both?
It would have been me and Mr. Margolis.
Okay. In separate conferences, as far as you recall. Is that correct?
Oh, I don't remember specifically. I was sleeping.
You said you what now?
I said I don't remember specifically. I was sleeping.
You said you don't remember? Are you at 14?
Yeah, I said I remember specifically. I was sleeping.
Okay. At first, I thought you said you don't remember.
Yeah, I probably did. I was sleeping.
Okay. Right. And the next day, when you talked to Mr. Margolis, did he indicate that he had spoken to Mr. Palladino?
Yes.
Okay. And is that when the decision was communicated to you that because this tape was a copy and it was a poor quality, and he failed a polygraph, that Chuck wasn't going to get all the money?
Yes, sir.
Okay. Oh, they thought this was important. Our hotel conference at our hotel with Chuck Freeman. Did you see that?
Yes, sir.
And above that, on 8/13/01 entry, it says conference at our hotel with Keith Williams, right?
Yes, sir.
And they're talking about our hotel. I think the suggestion was that you were in Kansas City.
Objection, Your Honor.
Were you there in
No.
Kansas City for those meetings?
No.
All right.
Not at all.
Let me show you the second page or the fourth page of that billing statement. Not the second, but the fourth. On 8/13 and 8/14/01, in this billing statement to you regarding the DoubleTree, what does Mr. Palladino indicate about the lodging that he paid for?
2 rooms, Keith Williams.
Okay, so it's not being published. Oh, if we could publish it, that to the jury. I'm sorry. What does it read?
Lodging, DoubleTree, 2 rooms, Keith Williams.
And in fact, in this discussion of the conferences that he has or that he does talk about, does he talk about conference at our hotel with Keith Williams?
Yes, sir.
Who is Keith Williams, or who was he?
He was a friend of Rob's. I don't remember the business he started in, but at some point he managed talent for a while.
So, did he have a connection with Chuck Freeman?
Yes.
Okay, and so when we're talking about our hotel, does Jack's billing statement make clear who the other person involved in this hotel is?
Yes.
Was it you?
Absolutely not.
All right. Then, well, they ignored the part of that billing statement. They did talk about Chris Wilson and ask you, was there any hotel room for Chris Wilson on Jack's bill? Well, let me ask you this. Did you hire Chris or did Jack?
I hired Chris.
Okay. Did you pay Chris or did Jack?
I paid Chris.
Did you pay for Chris's hotel or some combination of you and Chris pay for Chris's hotel, or did Jack?
I did.
Okay. And so would there have been any basis for Jack to put Chris' hotel room on his bill?
No.
And when the prosecutor asked you a question about these various meetings and testimony from Jane and her mom. So first of all, when Jane's mom testified, do you recall her testifying that at the meeting that she was at with you, Mr. Kelly, didn't say a thing about having done anything wrong?
Yes, sir.
Okay. And so you said you thought that she was confused about which or what meeting that she was talking about when you were testifying earlier today on cross-examination. Now, she had indicated that there was a meeting that she was at. Mr. Kelly didn't make any incriminating statement. Did you have a meeting with Jane's mom where you were there and no incriminating statements were made?
Yes.
Okay. Do you remember when Jane's mom was talking about what the content of the meeting that day was? She was talking about the trip out of town. Do you remember that?
Yes.
Okay. Was there a meeting with Jane's mom and her dad about a trip out of town?
Not Jane.
No.
Mom and dad.
Yes.
Yes.
And were you at that meeting?
Yes.
Okay, now they asked you questions about Jane, said about a meeting and hotel, and Jane. I'm sure you remember that Jane indicated that she did not recall you being there. Do you recall that?
Yes, sir.
And in fact, do you remember that Jane said that it was her dad and Rob alone in a room during that conversation. Do you remember that?
Objection, Your Honor. That misstates the evidence.
I'll put it to you in a different way. Although I think that's pretty clearly what she said, do you remember her saying at any point, Jane's dad and Rob went in a room alone? Do you remember that? You remember that, right?
Yes.
Objection, Your Honor. That misstates the testimony.
It doesn't. I'm not sure if it does, but he can answer if it's wrong. Okay. Did you hear her also say that while they were in there, Dad and Rob, she and her mom were outside sort of crying about the situation? Do you remember that?
Yes, sir.
And Mr. McDavid, were you there for any of it?
Yes, sir. Wait. Yeah. No, sir. I was sitting in the car.
And that would explain why Jane doesn't remember you being there, wouldn't it?
Yes.
Objection, Your Honor. That's not what Jane said. That's not the testimony.
That is exactly the testimony. Well, we could have it. If we could have it read back, please. The jury will remember what it is. So we'll let it go at that. I've got it. We'll talk about it in closing argument. Don't worry. Where are we here? Okay. Have you run out of questions? I'm getting there. I don't have too many more. They asked you the same question about whether or not when Lisa Van Allen was threatening Rob with a tape of him and his wife having a threesome, that he didn't want anybody to see. They, I guess they scrutinized you or criticized you for not calling the police. Mr. McDavid, what was the goal with respect to the tape with Rob's wife on it?
That nobody found out about it.
Okay, so did going to the police seem to be something that would interfere with that goal?
Yes, it did.
And who made the decision about how to handle it?
That would be Jerry Mongolis and Jack Palladino.
And anybody else? I believe Mr. Jensen was hired at that point. I can't believe he was ignored on this.
We haven't talked about Jensen for a while.
Right.
Of course, Mr. Jensen. I'm sorry.
No, that's okay. Knowing Mr. Jensen, I don't think he would have let himself not be involved in something like this. As one of you were questioned about the lawyers, and Mr. Jensen is dead, and Mr. Margolis is dead, and Mr. Palladino is dead. Mr. McDavid, did you have anything to do with the amount of time that went by before these charges were brought?
Objection, Your Honor. We have rulings on this prior to this case, and we can discuss at sidebar.
She opened.
I'll sustain the objection. All right. Well, they've raised the unfortunate notion that these men are no longer alive at the time.
Objection, Your Honor. If we need to discuss at sidebar, we can.
I didn't finish my question. I ruled. I'm not going to ask that question. They discussed this notion that the men were dead. They asked you that question. So I do have another question about that, though. One of the attorneys that you mentioned involved throughout the Sun-Times and the Sun-Times article about the Jane tape and the Palladino and the Chuck Freeman situation in Kansas City. Jerry Margolis did have a lawyer in Chicago that worked with him on those things. Is that right?
Yes, he absolutely did.
What was his name?
John Toohey.
Is John alive?
Absolutely.
They asked you about the video that was played in the 2008 trial. Now, and whether you saw it, first of all, did you see the whole video, or was a whole video even played as far as you know?
Well, I don't recall. I'd be speculating.
Okay. And do you know if the video one, we saw here is actually the same video that was placed there?
No, I do not know.
Okay. And you said that, and let me ask you this. From your vantage point, where you were in the courtroom, were you able to clearly observe all portions of this video that was played?
No, we didn't have these kinds of screens and stuff.
Okay. And you said that you would glance at it. You'd look away. Were you comfortable sitting there just watching the whole thing?
No.
Is there any way for you to recall some 20 years later, or 12, 14 years later, however many years it's been, the specific moments you saw, is there any way that you could possibly remember?
No. All I remember is Charles Powell back stuff.
Okay. After speaking about that, that was the Charles Palm frame by frame analysis of the back. That was a separate piece of video that was played by the defense. Is that correct?
Yes, sir.
During the testimony of Mr. Palm.
Yes, sir.
Okay. And that's the thing that you watched with Mr. Jensen before the trial.
Yes, sir.
So did you get to see that part clearly in Mr. Jensen's office and not sitting in the trial with the small screens away from you?
Yes, sir.
They suggested with their questioning that the reason Jane wasn't going to testify is because you and Mr. Jensen didn't want the truth to come out.
Objection, Your Honor. That's argumentative form of the question.
I think it is.
And it's commentary of counsel.
Sustained. She asked you a question that was basically whether or not you were trying to keep the truth from about the tape coming out by Jane not testifying.
Objection, Your Honor.
So my question is, I sustained the objection to that. That was her question, not mine. I heard. I sustained your objection to her question. And now you want to ask him the same question? Okay. Fair enough. Did you sustain the objection? You did sustain the objection. You're right, Judge. You're right. My question to you, Mr. McDavid, is when, if at any time, did Mr. Jensen suggest to you that he was intending to hide some truth about Jane from anyone?
Never.
And what was Eddie's explanation to you for why Jane needed to testify? Need not testify?
Because the case was won. The net result, he didn't want to put her through it. You know, he didn't want to have to deal with the prosecutors trying to tear her apart.
Did he ever indicate that it was because he thought that the truth would come out?
No, sir.
What was the only truth that Mr. Jensen said to you with confidence that was going to come out of the trial?
That the tape was fake.
And at that time, based on what you knew and what he showed you and what he had, did you have any reason to doubt it?
Not one reason at all.
She asked you whether you paid Charles Freeman not to come forward with information. So to follow up on that, what kind of information were you worried about from Charles Freeman?
Lord knows.
True information or false information?
False information.
What did you think that Freeman was going to do if he didn't get the money?
Make up lies? No, make up lies.
And what did Mr. Jensen say to you about what had to be done to prevent that?
This was like within a week of the trial ending. Mr. Jensen said, can't have this. This guy is going to get up there and make Lord knows what lies. I'm not going to lose this trial that has gone on for 7 years over some guy trying to extort Robert. He said, just pay him.
They asked you about some of these videos. Video 2 and video 3. Have you, before you came to this court, had you ever seen those videos played for this trial?
Never in my life.
Do you know, or do you have any way to know when where the videos came from that Chuck Freeman claims he got?
No.
Do you have any way to know whether he got them off the internet?
Objection, Your Honor. He just said, I have no way to know where he got that from.
Objection sustained. Let's get this over. We're getting there, Judge. I'm almost there. Lastly, Mr. McDavid.
Yes.
During all of those years, 2000 to 2008, everything that was, the government talked to you about things that you weren't present for. They talked to you about not being present to watch the tape with Mr. Jensen. Was it Mr. Jensen's practice with every videotape for him to be the one that watched them?
Yes.
Did you ever have any reason to believe Mr. Jensen would lie to you about the content on the videotape you bought?
He's not a liar. No.
Did you ever have any reason to believe that Ronald Winters, who testified under oath to being there that day and seeing that tape, would lie?
No.
Objection, Your Honor. It's argumentative.
Sustained. Mr. McDavid, you talked about Jerry Margolis. And Jerry Margolis and Jack Palladino personally telling you what the content of Chuck Freeman's video was, and that it was not any kind of video involving a person underage. At that time, what, if any, reason did you have to believe that Jerry Margolis would lie?
He doesn't lie. No. None.
What, if any, reason would you have to believe that Palladino would lie?
None.
All of the information that you have provided to you and shown to you by the lawyers from 2000 to 2008, what conclusion could you draw from that about the video with Jane?
That it was a fake.
No further questions? Is that it? Any redirect? Redirect is finished. Redirect? I'm finished, Judge. I know. I'm just asking.
The government does not have any recross.
All right. The witness is, all right, you can step down.
Thank you.
Witness is excused. Any further questions or evidence from the defendants, I believe?
We have a stipulation.
Ms. Judge, you have something?
No, go ahead.
Yes, Judge. I have a proposed piece of evidence, my client's passport, Defendant's Exhibit Brown 103.
Any any objection?
Yes, Your Honor. The government objects. The passport is from well after the charge in the case, so it's absolutely not relevant evidence to anything involving this trial. Oh, sorry. Go
Let me
ahead.
do this because that's defense.
Gotcha.
The indictment states the years that my client was employed for Mr. Kelly, and the passport encompasses those years.
All right, I'll admit it over the objection. Anything else?
Judge, we have a stipulation. I'm just looking for it. I think the government.
Miss Bonjean, I think I have to sign one here.
Okay, thank you.
One moment.
Okay, who is going to read the stipulation?
I am.
All right, Miss Cohen.
Oh, it's Miss O'Connell, actually. Thank you. I have a stipulation with regard to the.
All right.
Go ahead, Mary. Passport.
All right, read it.
It is hereby stipulated to and agreed to by and between the United States of America, its attorney, John Lausch, with the Northern District of Illinois, and defendants Mr. Robert Sylvester Kelly, Mr. Daryl McDavid, and Mr. Milton Brown, that the following facts are and should be considered to be true and accurate. Stipulation. Brown Defense Exhibit 103 is a genuine United States passport issued by the Department of State to Milton Brown on August 5th, 2011. The passport was given to the government on July 12th, 2019, pending the outcome of this case. Although the passport was current at the time, it has since expired on April 4th, 2021. The passport includes a photograph of Mr. Brown and stamps indicating various dates of international travel. Shall I move that into evidence, Judge?
Fine. Stipulation for Mr. Kelly.
Okay, thank you. It is hereby stipulated to and agreed by and between the United States of America, by and through its attorney, John R. Lausch Jr., the United States Attorney for the Northern District of Illinois, the defendants Robert Sylvester Kelly, Daryl McDavid, and Mr. Brown, that the following facts are and should be considered true and accurate. Stipulation. Hypnotic is an alcoholic beverage that was first introduced into commerce beginning in September 2001. So stipulated.
Okay. Further evidence?
We would move that into evidence.
Further evidence for the defendants?
None for Mr. Kelly.
How about Mr. McDavid? At this time, Mr. McDavid, rest, Your Honor. Miss Judge, on behalf of Mr. Brown.
Mr. Brown, rest as well.
Is there a rebuttal?
Your Honor, the government needs a few minutes to discuss and outside of the presence of the jury, if we may.
We'll take a 15-minute recess. Proceedings heard in open court. Jury is out. Okay, outside the presence of the jury.
Yes, Judge. I'm sorry. I should have clarified. We just need some time internally to discuss, since Mr. McDavid just ended his testimony, to see if there's going to be any rebuttal evidence.
All right. Well, we'll take our 15 minutes and have the witness ready to roll. Witness is ready to roll. If not, we'll suspend, send the jury home until Monday at 10, and we'll complete our instruction conference. We'll do that anyway, regardless of whether you have any rebuttal.
Yes, Your Honor. We'll report back in a few minutes if that's okay.
Ms. Bonjean, anything from you?
Judge, may I make a request? I'm dealing with the MTC about visiting Mr. Kelly this weekend. We've actually had no ability to visit with him because they suspend visiting at 3 o'clock. And there's no visiting on the weekends, which has precluded me from visiting with him at all throughout the trial. We've made do by visiting at lunchtime or in the morning. But my understanding is that if the court issued an order to accommodate so I can visit with him before closing argument on Monday over the weekend, I would ask for that.
All right. Can the government assist in communicating that to the marshal? I think it would be necessary so that, we can, because I've been under pressure to get this case finished. So in order to accommodate defense counsel, I'll order that they make a combination for her to visit for Mr. Kelly prior to 10 o'clock on Monday.
Thank you, Your Honor.
And could you assist in communicating that to the marshal?
Yes, Your Honor. Judge, we will. The order from you is really the key, I believe. We can, talk to them, but...
Yes, well, you can tell them I'm ordering it.
Yes, Judge.
Whether I have the authority to order it or not, I'm ordering it. That's the trouble with division of powers. You end up not having very many.
He is over it.
Been over it.
Recess from 322 to 340. Change of court reporters. All right, proceeding in open court. Jury is out. Is everybody here? Yes.
Yes, Judge. The government is asking for some time to meet and discuss a rebuttal case. If we do proceed, like I said, it would be very, very brief on Monday morning. I understand Your Honor's concern, but the defense case ended today. There was some information discussed that we're talking about, and we're just asking for additional time, given that it's almost 4 o'clock, to discuss that and get the witnesses here if we do have witnesses. Of course, we'll be communicating with the defendants, as soon as we solidify.
Well, tell me what the evidence, what's the material is that going to be? What is the subject of your possible rebuttal?
It's related to Mr. McDavid's testimony, related to some of the individuals he discussed. And I'm not at the liberty to confirm anything right now because we have to talk to certain people that we may call to see. So we need additional time, Judge. We need some time today to iron this out, and we're requesting to be able to present that Monday if we do proceed with that.
No, I'm not going to do that. We either do it today or not.
Okay, then we will need time to discuss because we don't have the witness here. We just need some time to discuss, Your Honor. And if we don't have that time, we're hamstrung to proceed essentially. Judge, Mr. McDavid's testimony over the course of the last 2 days, nothing he said today was inconsistent with he just kept restating his position over and over and over again. So if they had someone in response to what he said, they should be here now.
Well, I think so too. But if there is a report that you feel establishes some basis for being different, then, what he testified to, maybe you can stipulate the report is what it says. I don't know if, if they can do that or not, but, we would. Otherwise, I'm going to close. If you will, tell me precisely what it is that.
Yes, Judge. So we do have grand jury testimony from individuals that we would gladly offer in reports, but in particular today, Mr. McDavid was shown letters related to Barry Hankerson. He did not, recognize them. And so Barry Hankerson is someone that is on our list of people that we may call to discuss those matters. So that's what we're talking about here. We have those letters. If those are admitted into evidence, that would be part of the reason we're calling Mr. Hankerson.
What letters?
2 letters that were written to Jerry Margolis that Miss Apentag showed the witness. He stated he didn't know what they were. And that is one of the topics the rebuttal case that we're discussing, calling Mr. Hankerson to testify about those issues.
Judge, first of all, that was a letter written. I'm sorry, Bo, but it was a letter written from someone on behalf of Mr. Hankerson to Mr. Margolis. Why would Mr. McDavid have ever seen a letter that was not even addressed to him? And I don't know what bringing Mr. Hankerson in. I mean, again, I think they're trying to bring in evidence about his niece again, Aaliyah, which has been barred by this court already. I can't imagine the whole Mr. Hankerson thing went to Mr. McDavid's state of mind. I don't know what Mr. Hankerson has to say. I don't know what Mr. Hankerson has to say could even possibly be relevant to anything in rebuttal.
Judge, the point I would make is that Daryl said that he did not see the letters and didn't know what they were. Mr. Hankerson could not possibly rebut that. Mr. Hankerson doesn't know what Daryl McDavid saw, and I think it would be weird if he did see those letters necessarily. I don't see why he would have. Since he didn't deny, all he denied was that he had ever seen them and knew what they were. I don't think this would be an appropriate rebuttal. I think we would probably object to it. Your Honor, they've introduced numerous amounts of documents that were not written to Mr. McDavid or by Mr. McDavid. He read a lot of things and formed opinions off of things. Those are things that were communicated to this attorney, Jerry Margolis, that has, been so prominent in his testimony. We're entitled to explore that in rebuttal, and that's what we're asking for, is to, we want to admit those letters, and we can redact Aaliyah's name. We're not trying to.
I'm going to cut this. We're going to close the proofs today. So if you have further evidence, present it. If not, I'm going to rule that the proofs are closed. And I'll bring the jury back in and instruct them to be here at 10 o'clock for the final arguments. That's my ruling. So can you have them bring in the jury? And we'll send them home then. Does everybody have the red line and the instructions? Because I'm going to list what you did and then, let you make your objections as to my rulings, which we made before, if I can figure out my notes. Jury is in. Please be seated. It's my understanding that defense rests. Is that correct?
It is.
Yes, Your Honor. Yes.
On behalf of the defendant, Kelly, the defense rests.
Yes, Your Honor. Defendant Kelly rests.
And McDavid?
On behalf of Mr. McDavid, we rest, Your Honor.
Brown?
Mr. Brown rests too, Judge. Thank you.
All right. All right. Well, okay. Well, that does the government have a rebuttal testimony?
No, Your Honor.
So proofs are closed. Members of the jury, we will now suspend until 10 o'clock a.m. on Monday, and you will at that time hear the closing arguments of the attorneys. I will then instruct you as to the law, and then you will retire to consider your verdict. Now, it will be very important that you follow my instructions, not to read about the case or not to discuss the case among yourselves and, with anybody else until after this case is over. So have a nice weekend. We'll see you on Monday at 10 o'clock. Please be seated. No reason to stand. Ms. Bonjean, do you have anything?
Judge, may I waive Mr. Kelly's appearance for this portion?
Okay, yes. Mr. Kelly may be excused if he chooses.
Mr. Brown is going to leave as well.
Mr. Brown, if he chooses to leave, may go.
Thank you.
All right. Let the record show that the court met with, in open court, It says on the record several days ago it went over all the instructions that have been tendered by all the parties. The court indicated after hearing the arguments on how the court would rule on the respective instructions that were tendered. And the court has said that at the time that, that it would give you time to state your objections to those that you find objectionable. So what I propose to do, starting with the government's instruction number 1 and proceed through all of the instructions that were tendered and indicate how I've ruled and how your arguments and possible corrections, if I misunderstand any someone, that is that okay with everybody?
Yes.
All right. Well, the government's first 7 instructions, there was no objection given. They were stock ones. Number 1, 7th Circuit 1.01, there was no objection given. Number 2, no objection given. Number 3, no objection given. 4, no objection given. 5, no objection given. 6, no objection given. 7, no objection given. 8, there was no objection was given, and the brackets were removed. Number 9, there was no objection given, and the brackets were removed. Is that correct on that one? Maybe I better give you that one. Let me, while we check, is that right? All right. Number 10 is withdrawn. Number 11, no objection given, and we filled the bracket with that. Was it the names?
Number 10?
No, number 11, 3.13, I think. Isn't that the expert?
Yes.
Okay.
I said yes.
Yes.
I'm sorry, Judge. With instructions, which instructions are we on?
Go ahead and read, Mr. Thompson. Please, nice.
I think you were reading number from the proposed ones, and they have been renumbered in the package we have now.
Well, there are original numbers.
Okay.
We're on current instruction 10.
All right. I'm going on my notes. Anyway, the bracket was the name, the expert. Wasn't that it? And what? There was no objection given. Number 12, based on the U.S. versus Young, there was an objection, and that was refused. Does the government wish to argue that? I think it was the government that objected, or maybe it was the defense.
I think it was. I think I objected. I could be wrong, but it looks like I objected.
We should not speculate with any other person, whose name you may have heard during the trial is not correctly or currently on trial before you. I can't remember. I didn't write down who objected.
Yes, Judge. I think our objection on behalf of Defendant Kelly was that there was no basis for.
Okay, it was Kelly then.
Yes, there's no basis to include an instruction unless the defendant argues that he should be acquitted because the government failed to charge somebody else. I think that was our basis. That if.
Okay. Anyway, I refuse it. So, does the government wish to argue that? Hearing none, we'll go on. That's refused. 13, no objection given. 14, no objection given. Was modified. What was the modification?
14, you say?
It's number 14. Yes. We've removed the second full paragraph and the last paragraph, leaving the first and the third paragraphs according to my notes. There was no objection with the modification. Number 15 was 3.16, and that was no objection. That was modified. What did we do on that? Number 3 and 16, which is government's number 15 originally. It was number 15.
Is this the charts and summaries?
What's the charts and charts and summaries? Yes, There was no charts, I think. Wasn't that it? One or the other?
We made it charts.
Summary charts, I think, did we?
We made it chart, rather. That was a modification, and my notes indicate no objection. Number 16 was withdrawn. 17, which was 3.18, there was no objections given. Number 18, which was 4.06 and 7, there was an objection by Kelly, and my ruling was to give it modified throughout the bracketed material.
Yes, that was over our without it, right, Judge? That's what you ruled?
Pardon?
You ruled to admit the without the bracketed information.
Bracket.
Okay, I think that's over our objection, just for the record, right?
Right? Number 19 is 4.05. No, what are we freaking reading right now?
I have no idea.
I'm like reading this like, what the hell are we
talking about?
Is this the different? It can't be the charges because it's not 18
No,
charges.
it's not the charges, it's the instructions that they created and all the objections that they had to the draft instructions. And he's ruling on whether he's going to allow it or not.
Oh, gosh.
Why is that not just in the summary, like at the end?
It's an open court. I don't know.
Okay, let's get through this, I guess. Number 19 is 4.05, no objection given. 20, 410, objection given. Modified by adding, what did we add there? I can't read my writing. A person's under the age of 18, and we excluded the minor definition.
I think we took out minor because we're going to incorporate it.
Yeah, because of the problem between minor being 18 and then the other count was it's 17. So we decided to eliminate the definition of minor and just add a person under the age of 18. What number is that again? That was 20, and there was still no objection. I didn't write that down. Who objected to it? Anybody remember who?
Which part, Judge?
This is 410.
Yes, Judge. If this is the definitions.
Yes, definitions.
Yes, I think the court allowed to include the definition of producing, just as the government included the definition of other.
Yeah, I don't have that. Was that done producing? I have. Did I write that down? Producing? Add?
That comes from 18 U.S.C. 2258, Section 3.
According to my notes, it should have been, but I don't see it there, so.
Right.
We'll have that. Does that eliminate your objection?
I think the only other issue was whether or not the government wanted to think about whether they were going to persist with including the sadist or masochistic abuse in the sexually explicit conduct definition.
Let's see.
We objected to that part of the definition because the comments suggest to remove any that don't apply. And I think the government said that they wanted to think about their response to that. I don't know. That's my recollection anyways.
Now let's go ahead and take about a 5-minute break. We're gonna go in and wrap this up tonight. We're not far off. Let's take about a 5-minute break and we'll come right back, okay?
Okay.
All right.
Thank y'all. All right, y'all. I'm ready when y'all are.
I'm ready.
Okay.
I'm ready.
All right. Let's knock this thing out. Y'all know we stopped at?
I think 10.
10. Okay.
Mhm.
I don't indicate that was left open, but you don't want the entire paragraph for sexual explicit conduct. The definition of sexually explicit conduct, that's what we're talking about, right?
Yes, number 3, I don't think is applicable, just like bestiality isn't applicable here.
That's right. Does the government take out sadistic or meso, masochistic abuse?
Your Honor, you know we are fine taking it out. That's fine.
Okay, we'll take out number 3 and remember, renumber. The next number is 21, which 18 USC 2255. That's given us as modified by adding Jane. I indicate no objection on that. 22, no objection given. 23, no objection given. 24, objection refused. Which is that? 24, I refused it. I don't remember. It should be.
Hidalgo Sanchez?
Is this it? It was defendants. What is McDavid 7? Maybe that is it.
That's mere presence and association.
Pardon?
That's mere presence and association.
Yeah, I think maybe I refused it in favor of yours. I think it was.
We offered it and unopposed, I believe.
Yeah, I think we refused it.
Right.
Pardon?
Yes, I think that Hidalgo Sanchez was refused and mere presence was.
We have it now. The government need not prove the defendant was aware or played a role in every act of the conspiracy. The defendant knew every member of the conspiracy. Instead of the evidence need only show the defendant was aware of the aim of the conspiracy and made a knowing decision to join them. It's the original, and there was original. And my notes indicate that there was refused. And what is the current 24?
Judge, and my recollection was that Mr. McDavid offered the entirety of the pattern mere presence instructions. The government did not object.
Is that number 7?
Yes.
Yeah, I think it is. I think I refused the government's 24 in favor of McDavid 7. I think you indicate that we didn't refuse that, huh?
I have it in my notes, Judge, that we object to it. Defendant Kelly objected to it as the non-pattern instruction. We objected. I don't know, frankly, I don't have recollection of how the court ruled, though.
Well, I definitely have, and I wrote down refused, but the red line version doesn't know that. Number 24, that U.S. versus Hidalgo was left.
Judge, we removed that from the updated version.
That's our notes that the government removed that one.
It was over our objection. We took it out.
Okay, that was it. Okay, number 25, that was given as modified. Apparently, no objection. I don't have any objection. Is that right? Yeah. 5.08 was the modification. A defendant may not be convinced of a conspiracy that terminated more than 5 years before the indictment, which was returned in July of 11th of 2019. A conspiracy terminates when the charged purpose of the conspiracy is obtained and abandoned. That wasn't. And it's my indication that it was given as the way it was written. I read it. I don't have an indication of an objection.
Yes, Judge. I believe we objected to that, but we added it. So it follows what used to be government proposed instruction 25 is the elements for count 5, which were given with some modifications. And then you gave that is a McDavid proposed instruction that was given, at least in part, as the next instruction. So what you've read is what we have in our set.
Okay. Number 26, which is section 1519, there was objection. It was modified by combining, I think, 2 paragraphs, 2 and 3 added. I can't read my writing. Combined 2 and 3, okay? All right, according to my notes, there wasn't an objection. I indicated, I believe, I would give it as modified. Anybody wish to object to it?
This is our objection, right, Mike?
My bad. Sort of.
Judge, we have an alternative version. So for the record, we'll object and say we ask for alternative version.
All right. That'll be refused, and I'll give that. Number 27.
I'm sorry. And Defendant Kelly joins with Defendant McDavid on that.
Okay. The definition of something. What is 27? We remove something. Tangible object. Definition of tangible object. For count 5, we modified because we moved an agency of the United States, including Homeland Security, in an investigation or matter within the jurisdiction of an agency, etc. There was objection to the mod. Does anybody wish to state on the record basis for the objection?
Yes, Judge. The government does object to the removal of the 3rd paragraph.
Okay. Number 28 was withdrawn. 29, double jeopardy was refused. 30, I don't have what it is, was refused. What was 30?
Polygraph.
Polygraph, yeah.
Polygraph.
I refuse that. Anybody want to argue that?
No, Judge.
Count 31, count 6, 5 OB was given without objection. 32, count 6, section 2252. Hey, given no objection, modification of the spelling of Mr. McDavid's name. Anybody want to object to that modification?
No.
No.
Number 33, count 7 and 8, given without objection. 39 of 34 is refused. 35, 506.
Judge, we held off on this one. The government is requesting that this be added. Section 2 is alleged in the indictment for count 7 and 8. And so what we had discussed is adding at the top for purposes of count 7 and 8, because the evidence, as is borne out throughout the trial, is that Mr. McDavid, had, and this relates to the receipt charged in count 6 or count 7 and 8. So we are asking to include this. We held it in abeyance. We are asking to include this for count 7 and 8. That's the government's proposed 35.
Okay, that was refused, okay? 3506 adds tentatively withdrawn. That's right.
Yes, and we're asking that it be given, Judge.
Begs, counsels, commands, induces, or procures the commission of any offense and may be found guilty of that offense if he knowingly participates.
Judge, this is the count or instruction that I think we argued. It's really not been the government's theory of an aiding and abetting type of theory. They allege that every single defendant had a particular role in direct participation, and there has really not been a theory of, some sort of legal accountability that way. I think it's inappropriate under.
I always wondered in a conspiracy case why you need both, but
this is for.
It's usually given. It's tentatively withdrawn, and as I understand it now, they want to withdraw it. So, I will give it. Anyone object? Anybody state your objections?
Judge, My objection is that with respect to Mr. McDavid, at least in terms of count 7 and 8, the government's argument through their witnesses has been that he personally received the item. So you can't have it both ways. If you want aiding and abetting, you need to make that your theory of the case with the prosecution. In this case, their theory of the case is that he received the videos himself. That's what their witnesses said. Now, if they find their witnesses weren't very believable or whatever, that may be a problem. But the bottom line is their theory of the case has been, with their witnesses, has been that he received the videos himself.
Okay.
And Your Honor, just to add to that, I think the court pointed to something that is conspiracy, and it seems to be a conflict a little bit with this instruction because the overt acts, can be any co-conspirator. So it's already sort of embedded in that instruction, and I don't think that it's appropriate in the way they've charged this case and the way they've put it in their proofs that this instruction be given. And I join in Mr. Brinley's objection.
Okay. Oh, that will be given for your objection. 36, section 2422B, counts 9, 10, 12, and 13. There is an objection. Modified adding pseudonyms, and modified paragraph 4 also adds language. Let me see who objected. By objecting as defined in the following instruction.
That's correct, Your Honor.
In paragraph 4, somebody objected. Maybe Kelly?
No, I think, Judge, I had just suggested that we use the pseudonyms as opposed to the word minor. That was my objection.
All right.
I think the court agreed and that was changed.
Okay, I'll give it. Modified with the pseudonyms. 39, count 11. There is an objection that's given. I don't remember who objected.
Instruction, I'm sorry, government instruction 30?
9.
37?
It says to count 11. Another one of the count 11 instruction.
I don't think we did 37 or 38 yet, Judge.
I think we might have skipped some. We just finished 35.
This is 36. All right, 35 was given. Originally, the government was going to think about it, and, they want it, so we'll give it. So 36, section 2422, which is counts 9, 10, 12, and 13. I indicated I was going to give it as modified by adding the pseudonyms and adding the paragraph 4 language. Is that right? That's number 36.
Correct.
There's somebody. Oh, I'm sorry. Excuse me.
There's somebody who objected.
I think we're good on that one, Judge. I think we just went through that one.
Okay, 37. I don't remember what the source is. There was an objection I indicated I would give.
Yes, Judge. Just for the record, Defendant Kelly had objected and had proposed the Illinois pattern jury instruction for the elements of that offense.
Okay.
And I think you overruled.
Okay.
And that's our objection stands.
The objection is overruled. It'll be given. 38, count 11, section 2422B, modified by adding the pseudonyms. I indicated that it would be given, and I don't know if there was an objection to that.
Just Defendant Kelly had proposed using the pseudonym and taking out minor. That was the only.
Okay, 39, also count 11. There was an objection, as I indicated I would give that.
Correct.
All right, 40. Consent was withdrawn. 41 was no objection given. 42 given as modified. What was the modification of 42? We eliminated the bracketed material. The note should include the date and time. Okay, that was the kind of, what number was that? Clerk?
41.
41, that's 4.08. 42 is 7.01. That's given as modified. I don't know what the modification was. Apparently there was no modification. Don't give the breakdowns of the vote. 42 is given, no objection. 44, I'm sorry, that was 43. Is given no objection. 44 is given no objection. Verdict form, it's my understanding the only request was to have the not guilty first as opposed to the guilty.
Yes, Judge. Yes.
I said we'll do that.
We'll make that change. And Judge, on 43 for the bracketed, just as we are cleaning these up, how do you prefer, for the bracketed material on 43? What is your preference in terms of reading the verdict? Are you going to read the verdict form, just so we can clean up the brackets? I just wanted to get your...
I will, yes. Make that aye. I'll read it. All right, now there was a 45 had a telephone concerning there was an objection. I indicated that I was going to give it. A telephone is an instrument of interstate commerce, so I know there was, I think, a united objection on the side of the courtroom.
Yes, Judge.
McDavid number 5, let's see. What was that? It's replaced by court 1. The court's instruction. I think is 1. Didn't I rewrite it?
You did.
I rewrote it, and everyone didn't like it, if I remember right.
I strenuously object, Your Honor, but I have no specific complaints about your...
I think the government objected, and all defendants objected, so I'll give it. Number 6, McDavid was refused. McDavid number 7 was given without objection. McDavid number 8 is given. It's modified by adding Jane and Susan. The number 9 is given without objection. Then we get to Brown. Number 1 is withdrawn in favor of McDavid 7. Number 4 has been briefed. I read the briefs, and I think the government has the edge in this, particularly on the basis of United States versus Kern, which is in the 10th Circuit, which makes the point that there is, and I'll tell you in a minute the point, there is a distraction between the elements of the offense and the means by which the government may satisfy an element. The element is child pornography, and the means of satisfying that are the prospective videos 1, 2, 3, and 4. And according to the 10th Circuit, the jury need not agree unanimously on the means by which the element is proven. So the instruction tendered by Brown will be refused. And I don't think the 7th Circuit has, well, it certainly hasn't in this context. So you have your objection noted on the record. So for number 4 was refused. Are there any instructions?
Judge, we added in the revised set that I sent to your law clerk. We added it for purposes of counts 6, 7, and 8. The term minor means a person under the age of 18. We realized as we were putting these together that we do need to, address what a minor for those counts is under 18. And then, as we discussed in the last conference, for the other counts, we used the names and then the ages were defined within. So that's an additional instruction that we were proposed when we circulated them to everyone. So I don't know if you want to we just have a couple of things. So if you want to address that one first, if anyone has an objection to that.
I'm sorry, which instruction number is it?
So in the new set, it was instruction number 31 to follow count 6, 7, and 8. The patterns use the term minor.
I remember we had a lengthy conference discussion because of the fact that pornography is, 17 and under?
Right. So some of those counts is 18 and some is 17. So we were just specifying what it is.
Yeah.
because otherwise there is no definition for a minor in those counts. And so
I thought we took care of. Let me see.
I'm not sure that's. I think that's unnecessary because you've already defined child pornography with that age of under 18. It's already incorporated in the child pornography definition.
Which counts? Which counts are?
it's 6, 7, and 8. And so it's confusing because when you look at government instruction number 32, for example, which is
32, 33.
the proposed 32, it says, for example, the third element is the person knew both that the material depicted one or more minors. And so the same goes for count 7 and 8. The defendant has to know the videos depicted a minor, and for those counts, it's 18 and under.
Yes, but child pornography has been defined as a person under the age of 18. It's just duplicative. It's the definition of child pornography.
Wait a minute. The count, which one? Let's see. Enticement of Jane, Nia, Pauline, Brittany, 9. Counts 9, 10, 12, and 13. In order to find the defendant guilty, the defendant used the facility of etc. Nia, Pauline were less than 18 years of age. And defendant believed that Jane, Nia, Pauline, and Brittany were less than 18 years of age. I don't think you need to have.
It's count 6, 7, and 8, Your Honor. Then I think we have to add the age.
Wait a minute. Okay. Let me move to 6, 7, and 8.
It actually does raise a good question, though, about
a person knowingly receives. I think that clarification is helpful, so I'll overrule the objection and give that. What else?
Judge, you just pointed something out that I think could lead to some confusion. As you pointed out in the enticement counts, 9, 10, 12, and 13, it instructs a jury that they have to find Jane, Nia, Pauline, and Brittany were less than 18 years of age. They also have to find that they committed the offense or that the defendant committed the offense of aggravated criminal sexual abuse, which, as we know in the next instruction, is the government has to show that the minor or the individual was under the age of 17. So the jury is going to be, I think, confused that, well, which one is it? Is it 18 or 17? And in fact, it's 17 because you have to prove aggravated criminal abuse, you have to demonstrate that they were under 17, not 18. So it's one of those just weird circumstances where the actual offense, the sexual activity that's being charged, has a different age for a minor than the rest of the.
Well, I think it's clear when you read that. Well, I don't know if it's clear or not, but it's clear then, for 9, 10, 12, and 13, who is less at least 13, but under 17.
Right.
So that doesn't mention minor at all. It says, that the victim is at least 13 under 17. And in the other count, obviously it's confusing to have different ages and for different counts, but I don't know, what you can do about it. I think that it's reasonably clear by adding the definition of minor, so I'll overrule the objection on that. What else do we need to do?
Judge, there's just one more, and that is the government's request to include the hearsay instruction as you gave it today, given that there's going to be a lot of argument on the evidence that came in for a state of mind and how, it's going to be factored into the purpose for which the jury can review it. So we think it would be very helpful for the jury to have that instruction with them as they're reviewing the evidence.
And we would ask to renew the 404B instruction.
All right. We'll put both of those in. It makes more instructions to read, but I'll accommodate you with both of these. So we'll add those.
Thank you, Your Honor.
Anything else?
Not from the government.
Not from Defendant Kelly.
Mr. McDavid? Mr. Thompson? Did he step out to go to the bathroom or something?
Not from Mr. McDavid.
Okay.
Not from Mr. Brown.
All right. All right.
Go ahead.
Our instruction conference is officially over, and we'll continue the case at 10 o'clock a.m. on Monday morning. How much time do you need?
So, Judge, the government is asking for both our arguments for 4 hours combined.
4 hours?
Oh, that's too much. They won't be able to add. I'll give you 3 hours.
For open, close, and rebuttal, Your Honor?
Yes, because I want to get all this in one day, you know, when stuff, you know, with breaks and stuff. How about Kelly? How much time does Kelly want?
4 hours? Oh, wait. Kelly, what? Well, Judge, I tend to be short, but I mean, I don't think that I couldn't. I mean, I think 90 minutes to 2 hours for 13. I mean, I have 13 counts on this indictment, so at least 90 minutes, frankly.
90 minutes? 90 minutes for McDavid? I'll give you 90 minutes. And how much for Brown?
Probably an hour.
An hour? You hardly were ever mentioned.
You could renew your Rule 29 if that's the attitude.
I mean, the less you say, the better off you are, probably. No, that's unfair.
I don't have that much.
All right, 3 hours, 90 in an hour.
I'll take 90 just in case.
What? All right. Well, we should be able to get it all in then.
I mean, that's 7 hours?
90. The government has to talk about all of you. So they have a burden of proof. Remember that, in case you forgot.
Judge, are we going to be able to do that in a day? Mike is telling me no.
Not with those time limits.
Let's see, 3 hours and 3. That's 6, 7. We'll get it in. We'll make them stay.
Do we have an ability to start at 9 o'clock, Your Honor? Would that be possible? Would that help the situation?
We told the jury to come back at 10. I don't think we can call them. We'll cut their lunch we'll cut their lunch hour.
You can't do that.
Well, we'll do the best we can. If they can't, your rebuttal may come on Tuesday morning, but I think I want to get it done.
Judge, the one thing I don't want is the rebuttal to only be the only thing on Tuesday morning. That's the one thing I don't think is fair. I don't care how we divide it up otherwise, but we can't have the rebuttal without any defense argument on the same day.
All right, well, we'll make them stay late.
Okay.
Well, we haven't made them stay late yet.
They got a nice long Labor Day weekend. One more day than they were otherwise going to get.
They did. Plus, they got an extra day, which made me a liar. I said the hell, come hell or high water, we'll finish in 4 weeks.
We would have been exactly there.
We didn't do it.
It wasn't our fault. We would have been closing right now.
I believe one panel was told the 15th, Your Honor. So that one, I think you'll still be on track for.
All right, actually, it's the problem. It's the fault of the court system, the GSA, by making us close on Wednesday. All right. Well, I'll see y'all on Monday. Have a nice weekend.
Thank you, Judge.
We, Judith Walsh and Jennifer Costello, do hereby certify that the foregoing is a complete, true, and accurate transcript of the proceedings had in the above entitled case before the Honorable Harry D. Linenweber, one of the judges of said court at Chicago, Illinois, on September the 9th of 2022. Great job knocking out another day.
Woo.
Man.
The closing arguments.
Yeah, man.
Finally, McDavid is off the stand.
Yes, man. He was on there for what, 3 days?
Dang.
Something
That's
like
what I'm
that.
saying.
What in the world?
Boy. Well, y'all listen. We're gonna come back and try to knock this thing out. Closing arguments. We'll start on tomorrow.
Yeah.
Lady,
tomorrow's not a good day for me. I might not be able to join tomorrow at
not a
all.
good day tomorrow. Okay, I'll try to get keep Tanya up. Between if CJ can join, it'll be great if we can get both of y'all, because I think it's gonna be. We'll see who's reading tomorrow. We'll see. We'll play it by ear.
Okay.
But y'all listen. Y'all have a great night. Thank y'all for coming on once again, and God bless y'all.
Good night, everybody.
Good night, everyone.
Good night, y'all.
All right. Bye.
Peace out.
Haters, all good. Thought I couldn't when I could. Woo!